William Fenshaw, file 25 CR 544. We're here today for change of plea. It's anticipated by the state of Ohio the defendant withdraws previously entered plea of not guilty and enter plea of guilty to count 1, aggravated possession of drugs with an MDO specification. It's a felony of the first degree and also carries a mandatory maximum sentence. In exchange, the state of Ohio would ask the court to dismiss the remaining counts at sentencing. And it should also be noted the defendant is going to voluntarily forfeit all items that were seized during the investigation. Other than what's been spread upon the record, no threats or promises were made to this defendant to induce his plea. Thank you.
Thank you. Mr. Levine, does that sound accurate?
Good morning, Your Honor.
Good morning.
What the prosecutor stated is accurate. There has been full disclosure by the state of all discovery. I've had ample opportunity to discuss this matter in great detail with Mr. Fenshaw, and I believe that the contemplated plea will be entered knowingly, voluntarily, and intelligently. Thank you.
What's the status of the federal case?
Your Honor, that matter was continued.
So it's not been concluded?
No,
and
it's
and he hasn't been sentenced on that
I believe
case?
it's the 16th of September.
But he hasn't been sentenced on that case
He
yet?
has not been sentenced. The government had to request.
That's all right. I just want to make sure. So right now he's not serving a sentence anywhere?
No, he's just being held.
Thank you. Mr. Fenshaw, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes.
They indicated to the court they believe it's your desire to withdraw your previous entered plea of guilty to count 1 of this indictment along with the specification, plead guilty to those. The remaining counts would get dismissed and we would proceed to sentencing where a sentence of an indefinite prison term of 11 to 16 and a half years will be imposed. It's the only option there is. You understand that?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what you're charged with in pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you need a moment to speak with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that because I need to make sure you understand everything going on, all right?
Yes.
All right.
Yes, Your Honor.
Let's get started then. How old are you, sir?
I'm 54.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Okay.
Nothing.
Now, you would have received a copy of this indictment. It looks like you probably got it. Let me pull this up here. Oh, back in the middle of June sometime, a couple months ago. You remember getting that, the
Yes.
document that sets forth the charges? Now, in that document, then, you're charged with 4 counts. You're pleading guilty to the first count, so I'm going to review that with you to make sure you understand it. Again, if you have any questions, make sure you ask. But what's alleged here in count 1 and what you're admitting to is on or about April 12, 2025, in Concord Township, Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine, which is a Schedule II controlled substance. It's further alleged the amount of the methamphetamine equal or exceeded 100 times the bulk amount. Specifically, it was 833.68 grams, which makes the offense aggravated possession of drugs a felony of the first degree. Do you understand what you're charged with in pleading guilty to in regards to count 1?
Yes, Your Honor.
Any questions about it?
No, sir.
It's further alleged in the specification that the grand jurors find and specify that you are a major drug offender. Do you understand what that's all about, or do you need an explanation about
Yes,
that?
I understand.
Okay. You reviewed that with him, Mr. Levine?
Yes, he's reviewed.
Mr. Levine,
Your Honor, we have discussed that.
and what that entails?
Yes.
Okay. Very well. All right, so do you have any questions for me regarding what you're pleading guilty to, Mr. Fenshaw?
No, sir.
Now, there are 3 other counts of the indictment that are being dismissed. Is that your understanding?
Yes.
Any questions about those?
No, sir.
Well, then before I can accept your guilty plea to count one here, I need to make sure you understand the rights you are giving up. And you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be heard in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of the charge. You understand that?
Yes.
You understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes, sir.
Now, if we did have a trial, you'd have the right to have an attorney represent you at the trial. If you could not afford an attorney, the court would appoint one for you free of charge. Do you understand that?
Yes.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation to prove you guilty before you could ever be found guilty. You're presumed innocent of these charges. The presumption of innocence sticks with you. It stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden of proof there is in our justice system. What that actually means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge I just read to you beyond any reasonable doubt before you could ever be found guilty of that charge at a trial. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to try to do that, if we were going to have a trial, the prosecutor would bring witnesses into the courtroom to come in and testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions, and we call that cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, sir.
You further can request the court issue an order, call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and force you to get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if we did go to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding the court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all for me then regarding these rights we've just discussed? These are all the rights you have and all the rights you give up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, I do.
Do you still want to plead guilty?
Yes, sir.
Now, do you understand your guilty plea is a complete admission of guilt? You're admitting to the facts being alleged by the prosecutor regarding the count you're pleading guilty to, count one. We're not going to argue later you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading to an offense that occurred after March 22nd of 2019. I guess I don't really need to say that anymore. It's long if it's long enough. But it's called that's a qualifying offense, which any felonies of the first or second degree committed after that date are considered qualifying offenses and are subject to indefinite prison sentence. When I use the term indefinite, it means there's going to be a minimum sentence imposed and a maximum sentence imposed. For this particular offense, normally I'd have a range I select. The minimum sentence and the maximum is based on a formula. In this particular case, because of the major drug offender specification, I don't have any options. I must impose the maximum sentence for this offense. So that sentence for your minimum will be 11 years. To determine the maximum sentence, I take half of that, which is 5.5. I add it to that minimum of 11. That's 16.5, and that's how you get the maximum sentence. So in this case, the court will be required to impose a maximum prison sentence, an indefinite prison term of a minimum of 11 years, maximum of 16.5 years. Do you understand that?
Yes, sir.
Any questions for me about that?
No, sir.
Now, what that means in terms of being an indefinite sentence is that once you've served the minimum sentence, there is a presumption that you'll be released at that time. So after you serve the 11 years, there's a presumption you'll be released at that time. However, the prison officials do have the ability to overcome that presumption if while you are in prison you misbehave, basically. That if you commit institutional rule infractions, if they don't believe you're sufficiently rehabilitated, if you pose a threat to the community, they could schedule a hearing in which you'd be entitled to be present, and they could try to make their case that you should not be released at the minimum sentence because of whatever rule infractions you committed or whatever threat you pose or whatever the reasons are. And if that's determined that's the case, then they will not release you at that point. They will select a new date for that to be your release day, and there'll be a presumption that you'll be released on that new date. Same procedure could apply, though, if they believe that at that point you're still not sufficiently rehabilitated or still pose a threat, that you've been committing misbehaving, they can again try to keep you in longer. Under no circumstances, however, can you be kept in beyond the maximum sentence of 16.5 years. So even if you were there the whole time just misbehaving the whole time, breaking rules, you have to be released at under the maximum sentence. You understand that?
Yes.
Okay. Now, upon your release from prison, you will be placed on post-release control. Post-release control is sometimes referred to as parole. It's a period of supervision you will be on after you complete the prison sentence, and it will be for a minimum of 2 years, and it could be up to a total of 5 years. Do you understand that?
Yes, sir.
And while on post-release control, if you ever violate any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term is imposed by the court. Do you understand that?
Yes.
Let me go back for 1 second real quick. I think I asked your lawyer beforehand, but let's make sure clear. Right now, you're not serving any sentence anywhere. Is that correct? You're just in lieu of bond?
No, I haven't been sentenced.
No, Your Honor, there's a pending case.
Okay, and were you on probation or PRC or parole to any other courts or agencies when you committed this?
No.
Okay. The reason I ask that is if you're serving a prison sentence right now,
No.
I could run my sentence consecutive to that. If there is no sentence you're serving, I can't do that. I can't, even if there's a case pending, I can't run it to some possible future unknown sentence. I'm not allowed to do that. It's got to be already imposed, and that's why I wanted to make sure of that. So that's not an issue here. And if you were on probation at the time when you did this, or parole, there could be consequences there. Nothing I would do, but there could be consequences with your probation officer for committing a new crime while on probation. You understand that?
Yes, sir.
Right. And it doesn't seem like that's the case here. Now, aside from the mandatory prison term I've just explained to you, there are other sanctions that can be and will be imposed. There's a mandatory fine in this case of at least $10,000 that must be imposed, and I could fine you up to $20,000. I could order that you pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment. You understand all that?
Yes, sir.
I could also suspend your driver's license for up to 5 years. Do you understand that?
Yes.
Now, a few moments ago, I told you what the prison term was. I told you it was a mandatory prison term, which means you're not eligible for probation in this case. and that a prison term will have to be imposed. You understand that?
Yes.
And furthermore, being a mandatory prison term, you're also not eligible for what is called judicial release. Judicial release is a motion that you could, some people can file with the trial court that sentenced them, requesting that they be released early and placed on probation. You're not eligible for that with this case. You understand that?
Yes.
Further, you are also not eligible to earn good time credit while you are in prison towards reducing your prison sentence. You understand that?
Yes.
Do you want a moment?
No, we've already discussed
Okay.
it, so.
You don't need to tell me the nature. If I just heard him whispering something, if he needs a
We're
moment,
fine.
if you need a moment to speak to you, I'll give him that. Okay.
Thank you.
Lastly, when we do proceed to sentencing, you'll have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer can speak on your behalf, recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand whatever? Well, I guess in this case, there's really no option. Just one sentence that could be imposed. So, just wanted recommendations are just that. They're recommendations. I don't have to follow them. But with this case, there's only one option. So I'll be following it if that's what they're recommending, because that's all I can do. Let me ask you this: have you have any questions about the sentence that could be imposed here or will be imposed?
No, sir, we've discussed it at length in detail. And
You still want to plead guilty at this time?
Yes, Your Honor.
Have you had enough time to talk with Mr. Levine then, have him go over everything with you and answer all your questions? I don't want to know the nature of that, but you've had enough time?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes, sir.
Has he or anyone else made any promises to you about what's going to happen in sentencing? I guess he did. So you know what the sentence is. Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering your plea freely and voluntarily?
Yes, sir.
All right, then, Mr. Fenshaw, any questions for me at this point regarding anything we've talked about?
No, sir.
Do you need any more time to speak with your lawyer before we go forward with the plea?
No, sir.
All right, then, Mr. Geigerich, the prosecutor is going to explain for me what the facts would show, Mr. Fenshaw. Please listen to him, because I have some questions for you about that, all right? Mr. Geigerich?
Thank you, Your Honor. The case proceeded to trial. The evidence would show that on April 12, 2025, the defendant was subject to a traffic stop by the Lake County Sheriff's Department at Interstate I-90 at State Route 44 in Concord Township, Lake County, Ohio. He was pulled over for an equipment violation for a muffler and plate illumination. The defendant was the sole occupant of the vehicle, was found to be driving under suspension. He was arrested, and an inventory search of the vehicle was conducted. It yielded a scale with residue in the center console, a Samsonite bag with a grocery bag containing suspected methamphetamine, on the a Spartan Sentinel carrier with front and side back plates being body armor is located in the vehicle. A .45 caliber Smith & Wesson M&P pistol loaded was also recovered. $327 in U.S. currency was on the defendant's person, and he was wearing a shoulder holster at the time of the stop. Suspected narcotics were sent to the Lake County Crime Lab, where they tested positive for methamphetamine Schedule II, an amount of 833.86 grams. I mentioned, a scale with residue. I mentioned those items because they will be subject to forfeiture. Thank you, Your Honor.
Thank you. Mr. Fenshaw, were you able to hear what the prosecutor just had to say regarding what he believes the evidence would show if we had a trial?
Yes, sir.
What, if anything, do you have to say about those facts as he presented them? Are they true? Did you do what he said?
Excuse me. You don't have to respond.
Oh, nothing. Nothing, sir. I have no
Okay,
comment.
so is what the prosecutor said accurate? Did you do what he said?
Yes.
Very well. Then, regarding count one, charging with aggravated possession of drugs, a felony of the first degree, along with the major drug offender specification. What is your plea to those?
Guilty.
All right, I have in my possession at this time a 7-page document. It's called a written plea of guilty and judgment entry, which sets forth and explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand the document that you signed in here in open court. Now, my understanding is that before I walked out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, sir.
Mr. Levine, is that accurate? Did you read this over with Mr. Fenshaw, review it with him, answer his
I
questions?
did.
Did he indicate an understanding of it to you when you did that?
He did manifest a complete understanding of the significance of the documents.
Thank you. Is that correct, Mr. Fenshaw?
Yes, sir.
So you understand what this document says then?
Yes.
Any questions from me about it?
No, sir.
It also appears that you signed it in a couple of places on the page 5 and page 7, the last page. Did you in fact sign it?
Yes, Your Honor.
Mr. Levine, you witnessed that?
I did.
Mr. Geigert, you as well?
I did, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, finding the defendant guilty of count 1, aggravated possession of drugs, a felony of the first degree, in violation of 292511 of the revised code, along with the major drug offender specification. I will dismiss the remaining counts of the indictment at this time. Mr. Levine, is there any reason not to proceed with sentencing?
No, there's no legal reason why we shouldn't. I apologize for not doing this earlier. My client is obviously in custody. His wife, she resides in a family home in Novelty. As one might expect, family is in, shall we say, economic as well as emotional turmoil. If the court would grant leave for me to have my client sign an affidavit of indigency at this time.
Well, as long as you get it filed before the sentencing entry is filed, then that's fine. So you're going to have a couple days for that.
I'll do that today, Your
Okay.
Honor. That's fine. And beyond that, Your Honor, my client has been in state custody since he was brought over from federal custody. I'm not sure of the dates, but just request the credit for time served.
Let me look at that real fast. Well, it's probably in the jail list, right? Whatever the jail list says, I imagine.
I would imagine, Your Honor, because he was booked on 4/13, that's all I know.
Well, it's got to be the day they executed the warrant then, whatever warrant we had.
Correct.
4/13, you said?
Yes, Your Honor.
What's today's date?
Because the incident was 4/12.
Oh, so maybe he gets credit for that first day. I'll give him from the 12th. He's probably in the count with some other, so we'll give him from the 12th. I have 136 days that would be.
Thank you.
And we're going from April 12th. That's to be the date we're started.
Yes.
Okay. Mr. Fenshaw, you have the right to address the court before your sentence, and you can say anything you like. Is there anything you want to say at this time?
No, Your Honor.
Mr. Levine, anything else?
No, Your Honor, thank you.
Mr. Geigert, on behalf of the state of Ohio, anything the state would like to?
Nothing, Your Honor, thank you.
All right, well, this court has considered the facts and circumstances of the offense as they were related to the court. Considered the nature of this offense, the charge. Consider all of this in light of the purposes and principles, and what was said here. And I consider all of it in light of the purposes and principles of felony sentencing set forth in 292911. So the factors in 292912, obviously in terms of the seriousness factors, it's a large amount of methamphetamine, but that's what the offense is also. It's a felony of the first degree with a major drug offender, so that doesn't make it more serious. That's what makes it a felony of the first degree and the nature of it. So recidivism factors, the defendant does have a history of criminal convictions. He's been very respectful here and to the court. It appears he's been cooperative throughout. He's got federal charges pending against him right now. Those are all factors in regards to the recidivism factors that the court considers. I also note that this is a mandatory prison sentence which the court is required to impose. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to available community control sanctions. Therefore, it will be the sentence of the court. The defendant serve a mandatory indefinite prison term of a minimum of 11 years, maximum of 16 and a half years, with credit for 136 days he's already served. I need to advise you, Mr. Fenshaw, as I alluded to earlier, upon your release, you'll be placed on post-release control for at least 2 years, up to possibly 5 years. That's for the parole authority to determine the actual amount of time. However, it is mandatory. While in post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term I just imposed. I further need to advise you, and I touched upon this during the plea as well, but I'm required to tell you now, that there is a rebuttable presumption that you will be released from the service of your sentence after you have the expiration of the minimum sentence of 11 years. The Department of Rehabilitation and Correction, however, may rebut that presumption if at a hearing they make specified determination to the department that your conduct while you were confined, your rehabilitation, your threat to society, any of those, they could overcome that and rebut that presumption and keep you there if they do make those findings. At that point, they would select a new date for you to be released. There'd be a rebuttable presumption that you'd be released at that new time, subject to the same hearing and that I just explained if you continue to misbehave or not be rehabilitated or continue to be a threat. Under no circumstances, however, can they keep you in beyond the maximum sentence that I imposed. I am going to fine you the mandatory fine, the minimum, which is $10,000. However, as I talked about with your lawyer, if an affidavit of indigency is filed prior to the filing of the entry, and that will be at least a couple days, I will waive that fine. You will pay court costs, however. I think that's everything. Mr. Gagos, is there anything I've left out or omitted?
Forfeiture of the contraband and the item seized.
Why is that? Was that agreed to between the parties here?
Yes, sir.
He pled to the count as well as the specs, forfeiture spec.
I don't think there was a forfeiture spec.
It was a voluntary forfeiture.
Well, that's what I just asked Mr. Levine.
Yeah.
He didn't say that. He said he pled guilty to the forfeiture specification.
Your Honor, I'm sorry.
It was the MDO spec he played.
May I have one moment, Your Honor?
The gun, the body armor,
Yeah.
drugs.
Yeah, fine.
If you want some
The,
fun back up.
Gun, body armor, I guess holster.
Because I think I listed it specifically in the plea paperwork, what he was forfeiting. I don't know if
Well, I don't know. There's no specification. So if there's anything, it's based on agreement. Otherwise, the paperwork says narcotics, firearm, body armor, scale, and $327 in U.S. currency.
There you go.
We agree to that.
Okay, then that will be forfeited.
Okay.
I already dismissed the other counts. I guess that covers everything. Mr. Levine, anything else?
No, Your Honor, thank you.
And Mr. Gyrich.
Nothing, Your Honor. Thank you.
Thank you. Good luck, Mr. Fenshaw.
All right.
of State of Ohio versus Edward Zedzikowski, case number 25CR599. Defendant is present in the courtroom, represented by defense counsel Chad Mulkey. The previous date in this court, the defendant pled guilty to possession of a fentanyl-related compound, a felony of the 5th degree, with the forfeiture specification for contraband and instrumentalities. Since that date, a pre-sentence report and drug and alcohol evaluation have been completed. We are here today for a sentencing.
Thank you. Mr. Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
I do, Your Honor. Thank you. Your Honor, my client is 44 years old. He did receive his GED in 1999. He had, as of a short while ago, been working at Pizza Hut, maintaining employment part-time, Your Honor. Currently, he is on Social Security disability for degenerative neck disease. He receives money from Social Security for that, for support, Your Honor. As it relates to his drug use, which has been prevalent throughout his life, he is currently, he represents me, he is in continued treatment at Brightview with a counselor there named Jennifer Felger. He attends Brightview 3 times per week. Note for the court that when he was referred for his pre-sentence report, he tested negative for drugs as well as his pre-sentence interview. So he's trying to do what he can on his own initiative. He was proactive for this matter, Your Honor. While unfortunately the presumption for prison is overcome in this case, we would nevertheless ask this court to place him on a period of community control that does not involve any additional time of local incarceration. You know that the jail treatment program is an inviting opportunity for consideration, Your Honor, but in light of his Brightview treatment, Your Honor, his desire to remain sober in his negative test, Your Honor, we'd ask the court to consider community control without jail treatment program at this time. Thank you, Your Honor.
Mr. Jedzikowski, you have the right to address the court before you are sentenced. You can say anything you like. Is there anything you want to say at this time?
Yes, Your Honor. Your Honor, I am humbled to be here before you today. I acknowledge my guilt of the charge brought against me, and I take responsibility for my actions. I am a different man today than I was a year and a half ago at the time of my offense. I sought treatment on my own and have been clean for almost 6 months. I have been taking weekly drug tests since March and have passed every one of them. I am focused on my recovery. My family trusts me again. I have a life worth living today, and I hope you will take all this into consideration when opposing your sentence. Thank you.
Thank you. Mr. Mulkey, anything else you want the court to consider?
No, Your Honor. Thank you.
1 second, please. Mr. Gretzky, on behalf of the state of Ohio.
Thank you, Your Honor. Due to the fact that the defendant has been placed on probation felony probation, that is, multiple times and has never successfully completed it, including twice in this court, the state's recommendation is prison. Thank you.
Thank you. This court reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here today by the defendant himself, Mr. Mulkey, the prosecutor, the recommendations. I also received a couple letters in support of the defendant. I've read those and considered those. All of this is considered in light of the purposes and principles of felony sentencing set forth in 292911 of the revised code. As for the factors in 292912, indicating the seriousness, more seriousness factors, nothing stands out factually indicating it's more or less serious. As for recidivism factors, the court finds the defendant does have a history of criminal convictions. He has not responded favorably in the past to previously imposed sanctions. He's been on probation to this court before in the past, violated, ultimately had to be sent to prison. Drug abuse problem that relates to this offense, certainly can't find the defendant doesn't acknowledge it or has attempted to address it. He has, which is a factor, quite frankly, which his attempt to address it indicates recidivism could be less likely. He does appear to be genuine remorse. Under 2913B1, the defendant previously served a prison sentence which overcomes and rebuts the presumption for probation, permits the court to impose a prison sentence. I can certainly appreciate the state's recommendation of prison based on the defendant's past performance in this court on probation. However, at this time I will make a finding that prison would not be consistent with the purposes and principles of sentencing, and the defendant is amenable to an available community control sanction. And I place the defendant on community control sanctions for a period of 2 years. However, first there's going to be some consequences, and second, I don't know anything about Brightwood and what it entails. And I want to make sure the defendant gets some treatment. This happened, I understand, in 23, but he was using for over a year after that. I'm going to order the defendant serve 45 days in the Lake County Jail with 1 day of credit. I'm going to order that he immediately enter and successfully complete the jail treatment program. Follow all aftercare recommendations. Further conditions, the defendant is not to use any drugs or alcohol. He shall submit random urine screens. Those must be negative. That includes no marijuana. To attend 3 AA meetings a week and have a sponsor. Continue with medically assisted treatment. So what's the status? Are you able to work or you're not able to work?
I could work a couple of days a week. I've been working a couple of days a week till recently.
Just to last month, right? Look like?
Yeah, a couple of weeks ago, actually.
All right, well, I'll order that you maintain part-time employment. I won't make full-time employment, but part-time employment. Obtain a mental health evaluation and follow whatever recommendations, if any, are made for any type of counseling, if that they deem that to be necessary. To have one doctor and one dentist that could prescribe you medication. Specialist, if you have, that's fine too. But you can only get prescriptions from those doctors that probation is aware of. You can only get them filled at one pharmacy that they need to know of. Sign any releases they need to contact folks that they may want to contact. Take any medications as prescribed. Pay court costs and supervision fees. I'm going to order the forfeiture of the contraband and instrumentalities set forth in the specification. Jamie, anything else you want I should consider here?
No, Your Honor. Thank you.
Does Mr. Zajikowski understand all the conditions of your probation?
Yes, sir.
Any questions for me?
No, Your Honor.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while on probation, a motion to terminate your community control sanctions will be filed. If it's found that you did violate, I could extend your probation up to 5 years, impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 12 months in prison, so that's what's hanging over your head. You understand that?
Yes, Your Honor.
And that'll be consecutive to any other sentence you may be serving at that time for something else, or for any new case that if you were to pick up a new case. All right, Mr. Gretzky, anything else for the record?
No, Your Honor, thank you.
Mr. Mulkey?
No, Your Honor. Thank you.
All right.
Your Honor, we're here today for sentencing in two cases, each styled State of Ohio versus Cassandra C. Nowak. One case is number 24 CR 1127, the other 24 CR 1321. Ms. Nowak is present today in open court with her attorney, Mr. Jim Matthews. At the last proceeding, Your Honor, this was July 21st of 25, the defendant pled guilty in both cases. She pled on the case ending 11/27 to possession of cocaine and F5 under 2925.11a and a forfeiture. And in case ending 1321, it was the same charge, Your Honor, possession of cocaine and F5. Your Honor accepted pleas on both cases, ordered that the defendant undergo evaluations, PSR, as well as a drug and alcohol evaluation. We have read the reports. We are ready for sentencing. It appears that the defendant on case ending 11/27 has 158 days of jail time served, and on the other one, 15 days. There is no agreement as to sentencing.
Mr. Matthews, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, thank you. Your Honor, as Ms. Nowak indicated in her pre-sentence report, she is asking for community control. She does understand, obviously, that she has a significant criminal record, but now at age 54, she really does feel that she has only so many chances left, I guess, we'll say, to attempt to right the ship here, and that is what she is asking for. We have had her evaluated by representatives from Lake Geauga. They have indicated that if the court does place her on community control, that they would, at a date to be determined, have residential treatment available for her, and she would ask that the court consider that along with a period of sober living after residential treatment, and whatever other terms and conditions that the court would want her to complete. She has indicated that she will follow any and all orders of the court.
Ms. Nowak, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor, I do. I want to apologize for my poor life choices and my unwise decisions, Your Honor, and I also want to apologize to my mother for having to sacrifice her time and her energy to come out here today because I don't know how to be a responsible, productive member of society at times. Your Honor, I also would like to say that since being incarcerated this time, I've had a time to sit down and reflect a lot on my choices and the decisions that I've made and just my whole life. I mean, it looks like, if you look at my record, more than half of my life has been with catching cases and being an addict. The most amount of time I've had sober, put together, without being on probation was 3 years on my own. That was 2012 to 2015, Your Honor. After that, I started experiencing, I just started not doing what I was taught to do, is what happened. These past 3 years have been pretty rough for me. I've gone through 3 hardships, deaths, one being my son, an addict, and sexual abuse, sexual assault case, and I decided I went off my meds. And for me, mental health, being spiritually fit, emotionally and mentally fit, they all go together for me, Your Honor. The only thing I can say is I took this time to do things that were proactive for me in here. I went to churches, I hit meetings, I wrote, I journaled, I did anything that I could do that would take me out of my head that's going to benefit me, Your Honor. What's different this time, Your Honor, is I'm different. My attitude's different. My attitude's different. I get stuck when I talk to higher up because of my mental. My will, my drive, my ambition to stay sober and to live a sober life is different. I'm willing to go to any lengths to stay sober, Your Honor. You say jump, I say how high. okay? I'm not predictable or hopeless.
You're not what?
Predictable, like, oh, she's just gonna go back out there and do it again.
You're saying you're not predictable?
I'm not predictable,
And what's
no.
that based on?
That's
Certainly,
based
I mean,
on-
it certainly appear predictable.
I know, Your Honor.
I know how this is gonna end up.
I'm not hopeless, Your Honor. There's still hope for me, Your Honor. There is still hope for me. I can follow directions, Your Honor.
But haven't you said this before when you've been in front of judges? You've said the
I
same
haven't.
stuff.
No, I haven't said the same stuff before. I haven't, and if I did, I sure didn't mean it then, because I never said the stuff that I'm saying today, Your Honor. I haven't. Not the same stuff. I haven't. Okay, Your Honor. I mean, I could be part of the success story. I never said that. There's only a small percentage that makes it in this. Okay, I know how to stay sober. I just need to put myself into doing it. The only reason why I'm asking for treatment is because I need it and I can benefit from it. Okay, I need to just learn how to have more of a structured life again and to build a firm foundation, and be accountable for my actions, Your Honor. Be accountable for my actions today. And I stay open, okay? I can still learn, okay? I'm not closed-minded, Your Honor. I'm able to understand things today.
Yeah, but you don't do it. I mean, I'm not saying you can't, but you just don't do it. You don't put to use what you learn or use the tools that you learn. I mean, this record is horrible.
Yes, Your Honor, it is horrible.
30 years. 30 years. 30 years.
Yes, Your Honor, 30 years.
Just over and over and over. And I can't imagine that when you would go in front of judges, you're giving them the same spiel.
I know, given the same spiel. It was over and over again, Your Honor.
You didn't tell me you
I
wanted
can't-
treatment, you need treatment, I'm going to do what I need to do this time. You never said any of that stuff?
No.
I don't
No.
believe that.
I remember saying it once before. I did say it to Lucci. I remember saying treatment, and he put me through jail treatment, and I did the NeoCap program.
Where's that PSR? Why isn't that in her folder?
And then I messed up on that, but my will and my determination to stay sober is different. Everything is different.
So you wanted to get high in other times? You didn't want to get sober?
I didn't say it. No, that's not how it happened. A lot of it when they in the program when they say people, places, and things, and that's what I did. I went back to Cleveland. I started seeing a man, and he was using, and I just followed along with it. I didn't do what I was supposed to be doing. I didn't stay, and my son passed away, and just none of those are excuses. None of them to do what I'm supposed to be doing in society. I'm 54 years old. I'm supposed to be responsible and doing the right things. I'm supposed to be part of an example, not be part of the problem. I'm supposed to be part of the solution. I know these things. I'm just asking just for one chance, one opportunity to show that I can be that person. Please.
Haven't you been given these opportunities? I mean, Lucci gave you, I'm looking at what he did. I mean, he put you through treatment. You violated. He put you through more treatment. You violated. A review hearing was held. I mean, you didn't get sent to prison until after there was at least 3 chances that time.
Your Honor, a lot of that stuff I don't remember. I just don't remember. I don't, because of where I was at that time. I don't. Mentally, I don't.
Was there anything else you'd like to say?
No, sir, Your Honor. That's fine.
Thank you.
The best, thank you.
Mr. Matthews, anything else on behalf of the defendant?
No.
Mr. Devanshi for the state of Ohio?
Yes, Your Honor, thank you. As been alluded to already, the defendant has a long and storied and consistent criminal history over those 30 years, where she racked up multiple felonies. I believe she's in the double digits there. Also multiple prison sentences. I believe she's in the double digits there. And of course, a variety and a slew of PVs. She's been given a bunch of chances, as Your Honor has already noted. I believe she also has an open felony warrant as we speak. And of course, has been engaged in a variety of treatment options. So she's been given a lot of chances to work it out. It's lost on me personally as to why it would be different now. For all these reasons, Your Honor, we believe that the appropriate consequence would be prison, and we would of course respect we would of course respect the court's discretion as to the duration. Thank you.
Hey, Megan, can I speak for 1 second? So this pre-sentence report shows that you've never worked.
I worked, but it was just waitressing jobs, stuff like that.
So why didn't you tell them about it? That's employment. That's
That
work.
was in Ohio. That was like years ago.
Well, it doesn't say what employment did you have in Ohio.
Oh, I don't know.
When's the last time you worked?
I don't know.
So what do you do every day?
What do I do every day?
Yeah, when you were not in jail, what do you do every day? You wake up and what do you do?
I would take care of, take care of the house, take care of the dogs. I would,
What house?
clean, when I had my house, I take care of dogs. I take care of backyards. I cut grass. I flower.
Why don't you work?
I don't know, Your Honor. I don't know.
Is there a reason you
Mental
can't
health
work?
reasons. Just my mental health, just because of just rapes that I've had in the past.
Because of what?
Just rapes and stuff that I've had in the past, Your Honor. I just, being around men, a lot of men, I don't trust nothing. I don't trust people. I get schizoaffective.
So you're not going to be able to work if I put you on probation?
I can work 20 hours a week, I think,
Why can't you work more?
because of SSI.
Oh, all right. Well, that's an answer to the question.
That's why, Your Honor. Yeah. I didn't know what you were asking. Yeah.
Yeah, but you didn't say that.
That's all. Sorry. You were just asking why I ain't working. Yes.
Well, you're saying apparently
SSI.
you can't work full time because of SSI, which is I get it.
Yes.
I did not. You should have answered that way. I didn't know that.
Okay. Sorry.
This court reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. Considered the facts and circumstances of the offenses involved, nature of the offenses involved. I've considered what's been said here in court by the defendant herself, her lawyer, the prosecutor, the recommendations. All this is considered in light of the purposes and principles of felony sentencing set forth in 292911 of the revised code. As for the factors in 292912, factors indicating the conduct is more or less serious. Court notes that in both of these cases, the defendant was operating a motor vehicle at the time she committed these offenses, so she was under the influence of drugs and possessing the drugs while she was driving a car, found slumped over the wheel of a car. In the second case, her operating a vehicle at the time makes it more serious. Nothing makes it less serious. As for recidivism factors, almost all of these factors are present, indicating recidivism is more likely. Defendant has a lengthy history of criminal convictions, goes back 30 years. She has not responded favorably in the past to previously imposed sanctions. She's been on probation multiple times and has violated multiple times. She has served multiple prison terms before. There's a drug abuse problem that relates to the offense. I don't know how much the defendant. She's never done anything. She doesn't do anything about it. And apparently in the past she wasn't serious about doing anything about it. Under 2913B1, defendants previously served a prison term which overrides any presumption for probation, permits the court to impose a prison sentence without having to make any special findings. Prison is certainly consistent with the purposes and principles of sentencing. The only issue for me to determine, Ms. Nowak, is whether you're amenable to community control sanctions, meaning whether you're willing and able to follow the rules, do what's needed on probation, do what's required of you. Your history shows you're not amenable. I certainly understand completely the state's recommendation in this case of prison, because we've done all this other stuff before in the past, and it's been a waste of time, waste of people's time, waste of money and resources. Apparently it's nothing that you ever really meant before from what you say. But this time you're serious.
Yes. Yes, Your Honor.
Well, I don't believe it. But I will give you one chance, Ms. Nowak, and it's just one chance. Don't come back here on a probation violation with some excuse. I mean, the most tragic thing could happen to you. It's not going to be an excuse to violate your probation, to relapse. I don't care what it is. So I don't want you coming back here and saying, well, you know, such and such happened, and I relapsed because of that. Well, you're going to go to prison. And there's not going to be any explanations. And you've been through this before, and I know you've had probation violations before, and you've been continued on probation before when that happened. That will not happen this time, just so you know that. Don't think that if you violate, you're going to be able to come back with a second chance. It's not going to happen.
Yes, Your Honor.
But in each case, I'm going to put you on community control sanctions for a period of 2 years. In case 24 CR 1127, I'm going to sentence the defendant to 158 days in jail with 158 days of credit. In case 24 CR 1321, can I write on this? Is this all right to keep this? Sure. I'm going to sentence the defendant to 75 days in jail with credit for 15. Both cases, I'm going to order that upon a bed becoming available at either Oak House or Nevaeh Ridge, that the defendant be released from the Lake County Jail, and that she enter that facility and successfully complete the treatment program at that facility. Any balance of the jail sentence that remains in 1321 will be vacated. You're to go to the treatment facility, follow their rules, comply with the treatment that they're providing with you, and then follow all their aftercare recommendations.
Yes, sir.
Further, going to order upon your completion of the treatment facility that you reside in a sober living residence for 12 months. Follow all the rules of that facility. Further conditions, you are not to use any drugs or alcohol, including marijuana, in any manner. To submit random urine screens. When requested, they must be negative. A positive screen will be a violation of your community control sanctions. You're to attend 3 AA meetings a week and have a sponsor. You'd have one doctor and one dentist that you prescribe you medication, one pharmacy where you get them filled. You can only get your prescriptions from the doctors that probation's aware of, and one can only fill them at that pharmacy. Sign any releases they need so they can contact any doctors if necessary. You're to continue your current medication management and your case management services with Signature Health. I want you to obtain grief counseling for these issues that you have alluded to in regard that have caused you what you say is a reason to relapse that in the past few years here. Pay your court costs and supervision fees. You're not to have any contact with Neil Lasky or Lansky. What is it? Neil Lasky, no contact at all.
Okay.
Contact means not just face-to-face contact, it means phone, it means emailing, it means text messages, it means text messages from inside the jail, it means having other people reach out to him and talk to him, none.
Okay.
You're the one that said people, places, things.
Yes, Your Honor.
He's part of the people there.
Yes, Your Honor.
Order the forfeiture of whatever contraband and instrumentalities are part of the specification or included in the specification. And once you get out, you're at the sober living, you're to obtain at least part-time employment.
Yes, Your Honor.
Verifiable part-time employment.
Yes.
Megan, is there anything else I should be considering here?
No, Your Honor, thank you.
In case 24 CR 1127, I'll dismiss count 2. So, Ms. Nowak, you understand all the conditions of your community control sanctions?
Yes, Your Honor, I
Any
do.
questions?
No, Your Honor.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while on probation, a motion to terminate your community control sanctions will be filed. And if it's found that you violated, I could extend your probation up to 5 years in each case. I could technically impose more restrictive sanctions, including local jail time, or I could, and I will, terminate your probation in each case and send you to prison. It'll be 12 months in each case, and those 2 cases will be served consecutive to each other and consecutive to any other case that you may have picked up at that time. So it's 2 years of prison hanging over your head. Do you understand that?
Yes, Your Honor.
All right. You said this is what you really want,
Yes, Your Honor.
and you're going to do whatever is asked of you. Prove us wrong. The prosecutor doesn't think you're going to do it. I have my doubts, that's for sure, but I'll be happy for you to prove us wrong. Very happy.
Yes, Your Honor, thank you.
All right, Mr. Matthews, anything else?
No, Your Honor, thank you.
Mr. Devanche.
Just really quickly, Your Honor, upon a bed being open at Oak House or Nevaeh Ridge, is that correct?
Yes.
Thank you.
Did I say something different, or?
I was just wondering if I missed the third one.
No,
Those two.
there's only the 2 that I'm aware of.
Thank you.
All right, thank you.
Eric Lally, case number 25 CR 391. The defendant is present with counsel Nicolette Tomasic. We were last here on July 11th, 2025, where the defendant pled guilty to count 1 of the indictment, possession of cocaine, a felony of the 5th degree, along with the forfeiture specification, and we are here today for sentencing.
Thank you. Ms. Thomas, any reason not to go forward with sentencing?
Your Honor, we're prepared to proceed with sentencing.
Anything you'd like to say on behalf of your client?
Yes, thank you, Your Honor.
Go ahead.
We would like to ask the court today to give Mr. Lally an opportunity on community control sanctions with treatment. Your Honor, in speaking with Mr. Lally, he has made it very clear, even from the first time that I met him, that he is in desperate need of treatment. He's been having a hard time getting into himself, grasping at himself. And speaking with him, he is willing to do the jail treatment program. He's willing to do residential. He's willing to do sober living. He knows what he needs to do. He knows he needs to stay out of the Cleveland area and stay away from the bad influences. He did indicate to me he does have his mom for support. His mom does live out in Medina. So if Your Honor were to give him community control and residential sober living, once he's completed with all that, he would have somewhere to go. He just wants to make sure he has an opportunity to stay sober. I've been in touch with my social worker as well, Your Honor, regarding a couple different facilities. If Your Honor would allow me to do treatment, he's been looking into New Day and Lake Geauga. Those are actually 2 places that Mr. Lally had mentioned to me as well. So we'd just like to ask the court for an opportunity with treatment today. I know Mr. Lally does have a lengthy criminal history. He does have prior prison, and I know he did have a 10-year period of no new offenses, Your Honor, and I know he does have an active warrant out of Cleveland Municipal Court for drug abuse instrument. He indicated to me he wants to get these warrants cleared up. He does have a couple other ones, it looks like, for contempt failure to appear, so he wants to get these warrants cleared up. He wants to get into treatment, Your Honor. He wants to remain sober. When he was initially released from the jail, he indicated to me that was a terrible idea on his part to get out on bond because he did begin to use again, Your Honor. He did overdose, so he knows he has a major issue. He knows he needs a lot of help in order to try to remain sober. He's been in the jail for quite a bit now, so he's been sober. He has a much clearer mind, Your Honor. Thank you.
Mr. Lally, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. I realize I do have a drug issue. I've been fighting opiate addiction for probably 30 years. I lost the mother of my children is dead of it. My oldest son is dead of it. My last girlfriend's dead of it. I OD numerous times. I understand I need treatment. I've never had court-ordered treatment. I've never had probation. I do have prison sentences, but my last one was just a drug abuse, was 15 years ago. I have not had a felony in 15 years. The warrants I have are all misdemeanors, and they don't come get me. I was released from here. There's not even holds for me. So, I mean, they're not like felonies that are pending. And I understand possibly like the NeoCam situation. I mean, I understand I do need treatment, and I understand that it's a good program. It's just the numbers don't add up, Your Honor.
What numbers?
Okay, I got 3.5 months credit already. Okay, if I get sentenced to NeoCamp, I would have to wait 30 days to get in. That would give me 4.5 months. Plus another 6 months in NeoCamp. That would give me 10.5 months on 1 felony 5. And then have to go to treatment after that and 2 years of paper over a month.
The numbers shouldn't matter if you want to get better.
I understand.
So that tells me you don't care about getting better. Because the numbers shouldn't matter. You told me in this pre-sentence report that you understand it's going to be long-term.
Yes, sir.
And if you truly want to get better, you should be willing to take whatever, especially when you say it's a good program, and it is a good program, you should be willing to do it. You have an opportunity to do it. And the numbers shouldn't matter.
Okay.
Shouldn't matter.
Is it a drug treatment?
Yes.
It is a drug treatment, yeah. Okay. I mean, I was under the belief it was some kind of cognitive thing. It was like...
Well, it is too, yeah. It deals with cognitive thinking. It helps you think better, make better decisions. I mean, it addresses drug issues. It helps you with your thinking and making better decisions. It is a cognitive thinking program as well.
Right.
I know I'm not going to mislead you. Correct, Cindy?
Yes, Your Honor.
But...
All right,
I mean, if you don't want to go there, I'm not going to force you to go there.
Right. I mean, of course, I'd rather get out today and go to treatment, and have probation. I've never had an opportunity in felony probation. Like I said, I've never violated because I've never had it. But I'm putting it in your hands, Your Honor.
I'm not going to waste people's time and energy and money and resources if it's something that you're not going to be willing to put forth the effort and you want to do, because you're not going to be successful if that's the attitude you have going in there.
I
And
do
you're
need
not.
treatment. I understand that. I just didn't know if I need drug treatment, period. Like I said, I've been fighting opiate addiction for 30 years of my life. I probably OD'd 6-7 times. I'm here when they called me.
You could have
in the
gotten
hospital.
treatment. You don't need to commit crimes to get treatment. You could have gone and got treatment.
You're right. Well, I got caught with drugs. That was my crime, and I was stealing to get drugs. That's all I really got to say. I mean,
Well, I guess the question is this.
Yes, sir.
If I'm going to consider a long-term program, it's going to involve NeoCap. If that's something you don't want to do, then I need to know that. If you're going to go there and have a bad attitude and not put forth the effort, then we're wasting everybody's time. And you can do your time and then go out and go to the type of treatment you want to go to, and you think that's best for you if that's what you want to do.
right.
I need to know
like
that.
I said, ideally I would like probation and release and put myself in treatment.
Right?
Now,
Well, that's
if that
not
is
happening.
not an option, if I either have to go to A, NeoCamp, or B, prison, man.
All right, well, you can sit down. You answered
Yes,
my
sir.
question.
Yep.
Ms. Thomas, anything else?
No, Your Honor, thank you.
Ms. Scholes, on behalf of the state.
Thank you, Your Honor. The state is asking for NeoCap in this case. Given the defendant's responses, however, if you would like to complete NeoCap, the state will defer to the court.
This court reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. Considered everything that's been said here in court today. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11.
Your Honor, I will go to NeoCamp and complete the program. I will put effort in it. I know I need help. I need treatment. Prison ain't gonna help me. I really don't, I would rather get out, but you know what? If I have a choice, I'd rather work a program. I know I need the help.
Well, no question about that.
Yes, sir.
I mean, you've been doing this stuff for how long? How many years?
Probably about 30 years now.
Yeah, well, if you're truly sincere about wanting to be done with all this and try to get on the right track,
Yes,
it's
sir.
going to take work.
Yes, it will.
It's not going to be easy. And it's not going to be fun. It's going to take time.
I agree with you. I'm almost 50 years old. I want to be done with this, man. I want to get my
You
life
can
together.
go to other treatment, and you're going to be right back here, and you're going to be doing this other stuff. I mean, if you're going to do it, it's got to be done the right way, and you got to take all the resources that we're offering, and you may not want to do it, and I get it.
Mm-hmm. I understand.
But
Yes, sir.
if you're truly sincere about wanting to be done with this life, then you got to just realize, this next year I'm doing this. I'm going to put forth the effort. I'm going to go through these programs, and hopefully I'll be done with that old life. I mean, it's going to take some time.
I agree with you, sir.
We're not doing it to punish you. I mean, you need help. I recognize you need help. I could easily send you to prison based on your history. I'm willing to give you the help, but it's not going to be just help that's going to let you walk out of here or do some, short-term program and then be on your own, because it's not going to work.
Yes.
It's been 30 years.
Yep. I understand.
So
You're right.
I mean, quite frankly, I'm looking at, when I read your pre-sentence report, you seem pretty sincere about wanting to get help and do whatever you need. I was pretty shocked. I was disappointed to hear what your lawyer had to say earlier, that
You're
you weren't
right.
interested in NeoCap, because I could go, well, that's completely inconsistent and different from what I got
You're
from the
right. I
pre-sentence
just,
report.
thinking about the opportunity possibly getting probation, going right to treatment. I have 105 days credit in
Well,
jail
you're going to be
already.
out of it. It's not going to take that
And go
long.
to sober living. I understand I need the help, the treatment. I agree with you, and I apologize to the court for my outburst. I will, whatever I'm dealt, I will deal with it in an appropriate way.
I mean, you tried doing this on your own a little bit ago. You're in sober living. You just walked out, right? That's what led to
Yeah.
this case.
It was a couple years ago I went in. I've never been court ordered. I went and did treatment one time on my own a couple years ago. And
Well, I mean, I'm reading, and maybe I'm misreading this, but I'm reading
Okay.
your version of the pre-sentence report. It said you reported that you had left sober living with a woman who lived in Eastlake, and you relapsed immediately.
Yep. That was 2 years ago. I went, that was the first time I ever did treatment. I went in on my own. It was nothing to do with the courts. And I did 30 days.
That was 2 years ago?
Yeah, it was 2
No,
years
because the
ago.
very next sentence says you left the house you're staying at, went to a store, and that's when you got arrested.
Well, no.
So maybe it's just the way it reads.
Yeah, it was worded wrong. I think it was, a year and a half ago or something. Then I came, the girl picked me up from Eastlake. That's how I ended up back in Lake County. And I think I ended up moving out and moving back and then
Well, this
catching
makes
the
it
case.
seem like it was all on the same day.
No.
That you were
No, it wasn't.
left the place, you got picked up, you went to Kmart, stole that Kmart special, what is it called?
Special, Circle K.
Whatever, Circle K.
Yeah. No, it wasn't the same day. It was
All right, well,
probably-
let me continue on then. I've considered all that information, what's been said here, all of it's considered in light of the purposes and principles of felony sentencing. As for the factors in 29-12, factors indicating it's more or less serious, nothing stands out factually indicating it's more or less serious. Recidivism factors, almost all those factors are present. Defendant has a lengthy history of criminal convictions. He has served, as well as juvenile delinquency adjudications. He's been in DYS before. He's served multiple prison terms as an adult. Not responded favorably to previously imposed sanctions. Recognizes that he's got a drug problem that's related to the offense. I guess now I'm questioning myself in regards to whether he wants treatment or not. He says he does, and he's indicated he's willing to do whatever at this point. Other factors indicating recidivism is more likely. The defendant failed to appear for his pretrial in this matter, so he violated his bond. There's no factors indicating recidivism is less likely. Under 29-13B1, the court finds defendant has previously served a prison term that overrides the presumption for probation, permits the court to impose a prison sentence. Prison is certainly consistent with the purposes and principles of sentencing based on the defendant's history. But I'm going to give him one chance. We'll see how sincere he is about really wanting to get help. I mean, he'll either take advantage of what's being offered or he won't, and we'll be back here and he'll be back in prison. It's going to be one of those two. We'll see. I'm going to put the defendant on community control sanctions for a period of 2 years. I'm going to order that he serve 134 days in jail. There's credit for 104. I'm going to order that as soon as a bed is available at NeoCap that he be released and enter NeoCap, successfully complete the program at NeoCap following all their aftercare recommendations. After that, we'll have him enter residential treatment as we discussed, at Lake House or Concord Pines, complete that, follow our aftercare recommendations, and then he'll reside in sober living for at least 6 months. Not to use any drugs or alcohol, submit a urine screen. They have to be negative. A positive screen is a violation. Attend 3 AA meetings a week with a sponsor. Obtain and maintain full-time employment once he gets through all this. Obtain a mental health evaluation. Follow any recommendations, if any, for mental health assistance if that's needed. Take any medication as prescribed. Pay court costs and supervision fees. Forfeit the contraband and instrumentalities that were seized. I'm going to dismiss counts 2 and 3 as agreed to. Cindy, is there anything else I should be thinking about here I missed? Does Mr. Lally understand the conditions of probation?
Yes, sir.
Any questions for me?
No.
I need to advise if you fail to comply with any of these conditions or any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it'd be 12 months in prison, which would be consecutive to any other sentence you may be serving at that time for something new or you're being sentenced to at that time. You know, I hope you take advantage of it. We'll see.
Thank you, Your
But
Honor.
this is being put out there for you to do what you say you want to do,
Right.
not to punish you, even though you may think it, and I can understand why you would maybe think that. That's not what the purpose is.
Okay.
So, Ms. Gold, is there anything else for the record?
No, Your Honor.
Ms. Tomaszek?
No, Your Honor, thank you.
All right, good luck, Mr. Lally.
I appreciate it.
We are here in the case of State of Ohio versus Willie Crenshaw, case number 25CR311. Defendant is present in the courtroom, represented by defense counsel Corey Hinton. On a date previous in this court, the defendant pled guilty to carrying concealed weapons, a felony of the 4th degree, with a forfeiture specification for any rights of ownership that he had to the instrumentality in this case. Since then, the pre-sentence report has been completed, and we are here today for the sentencing.
Thank you. Mr. Hinton, any reason not to go forward with sentencing?
No such reason, Your Honor.
Anything you care to say on behalf of your client?
Yes, Your Honor.
Good.
I think that Mr. Crenshaw would be an ideal candidate for community control sanctions. He's been very cooperative with me. He's checked in. He's done what I've asked him to do. I know he came to his pre-sentence report fully prepared, participated in that. He has passed all of his drug tests that he's had while being out on bond. He is employed. He works at Amazon and KFC. I know that he was even working at Amazon this morning. He has family and friends here that care about him and support him. He has no prior history with the juvenile court, no prior criminal history. I have a feeling he's going to learn a lot from this, but I do think that community control would be appropriate, Your Honor. He did do some time in the Lake County Jail upon being arrested prior to posting bond. I'd ask that he have credit for those days and that all other conditions of his community control be non-residential in nature. Thank you.
Thank you. Well, Mr. Crenshaw, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
Yeah, I know how this situation make me look.
Talk up a little bit.
I know how this situation make me look, and I know words don't really mean a lot, but I want to apologize to the officers for not communicating and running right instead of just cooperating right away. And if you give me a chance, I can show you that I'm way better than what this situation made me look.
You know you can't own or possess or do anything with guns, right?
Yes, Your Honor.
Is that going to be a problem?
No, Your Honor.
Not going to be able to hang out with these guys anymore either. You know that?
Yes, Your Honor.
Is there anything else you want to say? You don't have to. I just want to make sure you said everything you said.
No, Your Honor.
All right. Mr. Hinton, anything else
Nothing further, Your Honor.
for the state?
Your Honor, since this is the defendant's first criminal offense, although it is a felony, the state would recommend community control sanctions. Thank you. This court reviewed the pre-sentence report and investigation. I've considered the facts and circumstances of the offense involved. Nature of the offense, what's been said here in court today by the defendant, his lawyer, the prosecutor, their recommendations. Considering all of this in light of the purposes and principles of felony sentencing set forth in 292911,
So the factors in 29, 29, 12. Nothing stands out to the court factually indicating it's more or less serious. As for recidivism factors, no factors are present indicating recidivism is more likely. As for factors indicating recidivism is less likely, the court notes the defendant does not have any prior convictions as an adult, although he's just became an adult. But he also has no prior delinquency adjudications. He's led a law-abiding life for a significant number of years. Appears to have and display genuine remorse. Under 29-13B1, the court notes the defendant did commit the offense while in possession of a firearm, which is a factor that overrides the presumption for community control. Prison, however, is not consistent with the purposes and principles of sentencing, and the defendant is amenable to available community control sanctions. So I'm going to place the defendant in the First Offenders Program, which is a program for individuals who don't have any prior criminal history and lessens any potential jail sentence that could be imposed from what normally is imposed to a lesser period of time, if any. I'm going to put the defendant on community control sanctions for 18 months. I'm going to order that he serve 4 days in jail with credit for 4 days he served, so I'm not ordering any more jail time at this point. Basically, I'm going to have it all hanging over your head so that it's there if you screw up. If you don't screw up, you're not going to have to do it. But if you do, then the whole amount of time will be left there. As conditions, you're not to use any drugs or alcohol, and that includes no marijuana. You have to submit urine screens if requested. They have to be negative. A positive screen will be a violation. You also can't screw around with or tamper with urine samples, bring in fake urine, someone else's urine, anything like that. You understand that?
Yes, Your Honor.
I want you to enter and complete the Decision Points program. It's a program we have with our probation department that, good program, just helps people making, with the decisions that they make and how to go out and make better decisions, the right decisions. So I'm going to have you complete that program. You're to obtain and maintain full-time employment or education. If you want to go to school, college, vocational training, get a certificate in some field, you can do that as well. But on a full-time basis, I want you working, going to some type of school or some combination of the two that keeps yourself busy full-time. You understand that?
Yes, sir.
All right. I'll order that you obtain a drug and alcohol evaluation, see if there's any issues there. If there are, we'll follow whatever recommendations come out of it. They say there's no issues, you don't need to do anything, then you'll be done with that. If they recommend you go to some type of outpatient treatment or AA meetings or whatever it could be, then you'll have to do that. But whatever they recommend you have to do. You understand that?
Yes, sir.
Okay. I'm also going to order that you perform 30 hours of community service, pay your court costs and supervision fees. I'm going to order the forfeiture of the firearm and whatever other items were listed in the specification. I'll dismiss the balance of the indictment as agreed upon. Nicole, is there anything else I should be considering here that I'm missing?
None of this time around.
So, Mr. Crenshaw, you understand the conditions of your community control sanctions?
Yes, Your Honor.
You're going to follow them?
Yes, Your Honor.
Okay, I need to advise if you fail to do that, or if you follow the rules of probation, so you're not going to jail, so you want them to come over today, Nicole?
Yes, Your Honor.
So when you leave here, you're going to go right to the probation department. They're going to sit down with you and go over all the rules, let you know what's expected, so make sure you do that when you leave here.
Yes, sir.
All right? But if you don't comply with my conditions or the rules of probation, if you leave Ohio without permission from the court, or if you commit a new crime while on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, including local jail time, or I could terminate your probation and send you to prison. And if I sent you to prison, it would be 18 months in prison. So that's what's hanging over your head. You understand that?
Yes, Your Honor.
I'm also going to order that the defendant have no contact with Kevin Burgess or Antoine Stugins, Studgins, the two co-defendants in this case. I will also order that bond be released at this time. So, Ms. Zagreski, is there anything else?
Nothing else for that.
Mr. Hinton?
Nothing further from the defense, Your Honor.
All right, Mr. Crenshaw, good luck with this. I hope you can prove to all of us, back up what you say, that this was just some one-time thing that happened and we're not going to see it back here, right?
Yes, Your Honor.
All right. All right, good luck.
All rise.